Okay, so welcome to everyone in the room, and especially to our online audience. We're quite excited to have at least us in the room are very excited to have a partial in-person event. But you know, hopefully it's a step towards having an in-person audience as well. My name is Judy Lang. I'm the Saudi Professor of Philosophy and Medicine here at King's College London. And I would like to welcome everyone to our first colloquium in a series on philosophy and the Mental Health Act. This is the first in the series that we organize where we explore philosophical aspects of the Mental Health Act and psychiatry in general. Now, today, to introduce the reforms in the Mental Health Act, we have a fantastic panel to discuss these reforms. Before I introduce the panel, I just want to say thank you to the Saudi Foundation for supporting today's events and the rest of this series. And I want to encourage the audience, if they haven't already, to check out our webpage and sign up if they want for our newsletter and Twitter feeds. I think links in the chat should appear right now. So the way that today is going to work is we'll first hear from each of our panelists in turn for about 10 minutes. I wanted to not have questions after each panelist's session because otherwise it will take so long. But if there's something particularly burning or there's a question of clarification, if the audience can either put a question or a Q in the chat, then I can potentially take one or two questions, but I kind of reserve discretion to move them to the Q&A at the end. The panelists then will have a chance to interact with each other and raise questions and comments. And then we have a general Q&A for the audience. And in the middle, we'll just have a brief break for bathrooms and other comfort things. So with that, I think I'm going to introduce each speaker as they speak, rather than the whole panel as a row, because I've spoken long enough. So for our first speaker, I'm delighted to introduce Professor Simon Wessely, who's Professor of Psychological Medicine at the Institute of Psychiatry, Psychology and Neuroscience here at King's College London. He's also a consultant psychiatrist at the Maudsley Hospital. And Professor Wessely led the independent review of the Mental Health Act that has paved the way for the new 2022 legislation. So he's well placed to introduce us to the issues. Over to you, Simon.
Thank you very much. Well, actually, I'm not well placed to do that, because I first of all need to explain to you the peculiar system of politics we have in this country. Well, you know that already, but particularly when it comes to inquiries, because in most countries in the rest of Europe, expertise is valued. But Britain always has the amateur tradition, and we can see it in our Prime Minister, but in many others as well, of not actually liking people who know anything about the subject. We're preferring amateurs at all things. And in order to lead an independent review, and I was asked to lead one on the Mental Health Act, the first thing you have to prove, or they have to prove about you, is that you know nothing at all about the subject that you've been asked to lead on. And so we went through a process of due diligence in which they went through every single tweet I've ever made, every single paper I've ever written, every talk I've ever given, etc., to check that I literally knew nothing about the Mental Health Act. I don't even use it. So the bit of psychiatry I do doesn't involve that kind of work, and I haven't actually done a section, as we call it, for maybe 30 years. So I passed that bit with absolute flying colours. And there is a serious point to that. It means that nobody knows what you think about the subject, including yourself. So, and I have to also say that then going out, then went 2 years, they say that if you do this, they say, well, it'll take about a day and a half a week. And Steve over there will remember, it took about a day and a half a day, would be a reasonable length of time. But it was an incredibly, it was genuinely actually very enjoyable. It was very challenging. You have to learn very quickly. I went back to my kind of roots as a, when I was a junior trainee in psychiatry, doing the kind of severe mental illness part of the spectrum, and I haven't done that ever since then. And you learn very quickly. You had to interact with huge numbers of service users. We're going to hear from you, but also other academics in the law, because the Mental Health Act is not, psychiatry is only a small part of it. It's also about the first time they've ever had an independent review that wasn't led by a lawyer, actually. They'll probably go back to lawyers again, I would imagine, after the mess we made of it. But it's justice comes into it, policing comes into it, all sorts of things. And of course, philosophy, rights, all sorts of things come into it. It's a magnificently complex issue. and absolutely fascinating. We had a big team of civil servants that became a small team when Brexit loomed, all of whom looked about 6, but were absolutely, as you remember, Steve, also brilliant. And whatever else, I will never hear any words said against our civil servants, because they were, without them, we wouldn't have done it. And so anyway, now what I remember is the first thing that I learned from the judges that we also had working with us very closely is that mental health legislation, the Mental Health Act in particular, I think are part of what we have in what we'd like to call a civilized society. And the way that our judges explained it to me, which I understood very well, was it's about 2 separate issues. The first issue, which I presume you're going to talk about because you normally do, Gareth, or I haven't seen you for a couple of years, but I don't think it's changed much, is about our basic human right of autonomy, that we make our own choices. And increasingly in the law and in society, we make our own choices, even when they're dreadful choices. We have a right to make really bad, awful choices, even to the extent it might cost us our own lives, as some choices that people do have that. And in medicine, the paternalistic attitude that I grew up with, and you probably still did when you were at medical school a little bit, but we certainly did, has long since vanished now, and people have the right to make choices, even bad ones. But the second right people also have, what society has, is to protect those who are extremely vulnerable. And a decent society does that as well. It protects the very young, the very old, people with dementia, and amongst that is the people also with very severe mental illness. And balancing that is what a Mental Health Act exists to do, to balancing 2 things that are mutually incompatible, both important, but somehow we have to do it. And if you visit countries that don't have mental health legislation, or do have it but don't use it, they are not places where you want to be severely mentally ill. So that was the background that I learned, and always it was going to be about achieving a compromise. The second thing I learned was that the last time, which I did vaguely remember, which was it 25 years, 30 years ago, when Professor Richardson started out? When was it? It was quite a long time.
Late 90s, her.
Yeah, it was.
It?
Yeah,
her review.
And I do remember her telling me how awful it had been. It was at a time when coercion was on the increase. It was in response to a series of really awful, bad things that had happened. Homicides committed by people with mental illness. I was a Home Secretary who was, although Labour was still quite coercive, I suppose is the way of putting it, and the pressure to produce an act that would further restrict the rights of people with mental illness, to protect the public, was all about public protection. We were very lucky, and to the credit, and these are words not often said of the Prime Minister anyway, of any Prime Minister, but this was Theresa May, the instructions that I finally got from the Prime Minister were not of that. They were actually very different. And it's the one thing I need to remind myself what they were, so I can tell you what our remit was and not get it wrong, as I always do. We were asked to look at, number 1 was the rising rates of detention. So although my background is in epidemiology, and I knew that the rates of severe mental illness had not altered really since we started measuring the rates of severe mental illness, the rates of coercion and detention had definitely increased. Why? Second was, will we get onto this today, but was the overlap between the Mental Health Act and the Mental Capacity Act. We have 2 acts in Great Britain, which are extremely confusing to absolutely everybody, and I'm afraid still are. But we were asked could we sort out that, which the answer was no. The third one was, we were asked, were we up to date with developments in human rights? Not European human rights, of course, only our own human rights, because I did learn also how to deal with politicians, which is when you were dealing with Labour, you talked all the time about human rights because they liked human rights, that's okay. When you're dealing with the Conservatives, you always talked about choice, and the importance of choice because they like choice. Choice is a good thing, but you don't mention human rights because that's ECHR, which most of them still think is part of the EU, although of course it's not, but they don't know that. So you learned to change your message according to who you were talking to. The fourth bit was on issues around learning difficulties and autism, which I don't think we're going to talk about today. And the last bit was the shameful, disproportionate overrepresentation of those, particularly from Afro-Caribbean heritage, in those who've been detained. And when you got to one particular part of the Act called community treatment orders, the disparity was actually 10 times. So you're 10 times more likely to be on a CTO if you were from Afro-Caribbean heritage than if you weren't. And even though the rates of illness are slightly higher in that group, nothing remotely like that. So those were the things we were asked to look at, and I'm sure, Steve, you're going to talk about more about how we did that. And the main things that we majored in the end on was, number one, was about the fact that, and the quote I've remembered now, that I used to use a lot, was from one of the service users involved in the review, a lady called Kate King, who had been detained under the Act on 2 or 3 occasions, I think. And she said straight away that she knew, looking back, she knew that she'd been extremely ill, and she had no doubt at all that the Mental Health Act had saved her life. But then she said, why did it have to be so effing awful? And I just remember that all the way through, that it remained important for some people that periods of their life of extreme distress and disturbance, that using the Mental Health Act as a substitute decision-making would remain important. But why was it so awful? And why, she said, was what she wanted. A very bright, touching woman. She knew all sorts of things that she wanted, even when she was severely ill, and yet was treated, as incapable of making a decision about everything. So that was the main issue, in which are most of our recommendations. And I promised we would only make 20, just like I promised I would only speak for 10 minutes, but I will, don't worry. We'll keep to that promise. I said we would only have 20 recommendations. Unfortunately, we ended up with 230, which is terrible, really. And I'm now going to read them all out to you. But the most important ones, if I was to say one area where I think we made the most progress, and it was the area which on the day we landed, and it's important if you do a report, you think from day one, how is it going to land? Because the one thing you don't want your report to be is to be on shelves like this, where most reports end up. You want it to be acted on, is to ensure that on the day it lands, the government of the day, whatever complexion they are, accept some of your recommendations. If they don't accept any, you are doomed and nothing will happen. And the ones they immediately accept were all the recommendations we made towards improving choice at all stages of the process. And I still think that is probably the single bit that we're proud of all the things we did, but that one, we also put in a couple of recommendations we thought they would refuse, but they didn't, and that's, I'm not going to tell you what they were. They did drop some of them we thought we wanted, but there were a couple we put in because you always have to have a bit of red meat to say, well, we've listened to you, and we've changed our minds on that, but they allowed that one through, which is surprising. But it's about the increasing autonomy, increasing the ability of someone to make an advanced directive, or whatever we're going to call it, doesn't really matter, but to say, this is what I want to happen, because regrettably, most people who've had one episode of severe mental illness will sooner or later have another, and to make sure that that is respected as far as it possibly could be and is reasonably possible. And those are the major changes that we made in the white paper, and I'm very confident, even with COVID, will eventually become legislation when circumstances permit, which hopefully is next year. So that's the introduction to how it all went. Steve.
Thank you very much. Yeah, I just think that did you spot any open questions in the chat? If anybody has anything burning, Mr. Simon, put it in the chat. Otherwise, I will introduce our second speaker. We're extremely privileged to have Steve Gilbert here, who is a serious mental illness living experience consultant for the Department of Health and Social Care. He's been involved in the government response to the Mental Health Act review, specifically in formulating decisions on policy positions and a section of the BAMI mental health. And he's also an anti-racism consultant. So Steve, over to you.
I think I've got some slides, which is brilliant. Thank you very much for having me. It's quite interesting that I haven't actually had a lot to do with it for the last 18 months, but there seems to be an increase in the conversation around this, which is really, really good. So, hi, I'm Steve. And just very quickly, kind of my credentials from a lived experience perspective, I've got a really long and varied history around mental illness, both myself and my family. I've had multiple major depressive episodes and periods where I wanted to take my life and actually made attempts. In 2010 when I had a manic episode. I ended up being detained by the police under Section 136 and then was detained under Section 2 of the Act. And I spent a total of 21 days in hospital. My friend got me out as quick as possible. And the reason I say that is Simon's already mentioned Kate, and Kate spent about 7 years of her life in hospital. The two experiences are worlds apart. But I can tell you that 21 days with a locked door between you and the world is long enough to understand the impact that this can have on your life. I'm biracial. Again, part of the reason I say that is again, you know, part of my family is white, and that has an impact on me, and part of my family is black. I've always been viewed as black, and again, that's kind of had quite a significant impact on my life. And it's really fair to say that the way in which mental health services, the way in which our society has kind of been built up, has really played a huge role in my family's experiences of severe mental illness. I've got a formal diagnosis of bipolar disorder and a secondary diagnosis of complex PTSD. And over the past 10 years, I've done all the things I'm meant to do, appointments with psychiatrists, my CPN, talking therapy, lifestyle changes, medication, and yet I still find myself becoming unwell at periods of time, and I'm just recovering from a depressive episode and a period of psychological abuse. So if it looks like I'm reading, it is, because otherwise there is nothing in my head. And for the past 7 years, I basically have been paid to talk, and apparently someone thinks I make sense, which probably says more about them than me. So on with the discussion. So Simon has really kind of laid out the area that we're looking at, and he mentioned those terms of reference, and there they are, just for the sake of you all at home. And the first part I'm going to talk about is really the review structure. It is incredibly difficult to explain how many people were involved in this process, but this is my lame attempt at it. We had Simon and 3 vice chairs, and I was one of those, and we had a core working group of about 15 people. We then had a dedicated service user carer group of 12 amazing individuals, and we also had a dedicated African Caribbean group, which was co-led by Jackie Dyer, and an amazing contribution by Dr. Lade Smith. And then we also had a much larger advisory panel, which numbered approximately 40 individuals. We had the secretariat, and then at the midway point when we went into the topic groups, I think we estimate we had about 200 people working on the review. It was a phenomenal effort. And the reason I say that is that I think sometimes it's very easy for someone to sit there and criticize what we did or didn't do. We tried our best, and we tried to include as many people as possible. I'm just going to kind of show how we did that in different ways. I've already mentioned the service user carer group. Without them, the review would not look the way it did. And they pushed us really hard. They pushed Simon, they pushed me, and they were involved in absolutely every aspect of this review process. In terms of the African and Caribbean group, I've mentioned 2 key individuals. We had, I think there was a team of about 8 or 9 of us in total, and that was really to lead the work to understand the disproportionate number of people from particularly Black, but also kind of non-white communities, and try to understand why their experiences are the way they are, and to look at options to really address this. We had 50 focus groups. So what we did with this was, rather than it being centrally led, we created a framework that could then be used by groups up and down the country, and really allowed us to focus on some quite specialized experiences, particularly around kind of Black and non-white communities, but also around learning disabilities and autism. We had a service user and carer survey, which received over 1,500 responses. And again, you can go, well, why wasn't that number greater? And I think one of the things that I really want to focus on is that it's not easy to talk about one's experiences of the Mental Health Act. It's not easy to talk about one's experiences of mental health, full stop. And I think that rather than kind of looking at it as a numbers game, I am so thankful to every single person that contributed in the ways they did, because it really did help us to learn about the experiences of the attitudes to detention under the Mental Health Act. We also had bespoke round tables, including 2 at number 10. And again, you know, that just kind of shows the priority that it has and had at the time. And me and Simon and many of us were on trains up and down the country to go and see people where they were, which was a really interesting process in and of itself. And as I said, we had 18 topic groups in the second phase of the review. We got to a point where we did the interim report, and we looked and we had these 18 key areas that we knew we couldn't do justice to, and we didn't want anything to get missed out. So we set up these topic groups, which was a real stroke of genius. And we basically leveraged time and the experiences and the understanding and the expertise of other people, including service users and carers. And that really led to the development of the review. We held 7 public workshops. One of them we held here in this building, and they were rough. You put yourself in front of a group of people who have got very strong views about how the act should develop. And again, you know, that was a large degree of public scrutiny. So that's kind of the governance. That's just to kind of show the different ways in which people were involved. And the review really sits under 4 principles. And these 4 principles, again, came about in particular because of the service user care. They really drove hard for these. I think the challenge is that they have to be not only meaningful, but they have to have, be legally implementable. And those 4 principles are as follows: choice of autonomy, least restriction, therapeutic benefit, and seeing the person as an individual. Again, in the cold light of day, when you look at these, you go, well, surely that's common sense. Maybe. Are they routinely delivered? No. So again, it does really kind of, you know, make you think, why are we having to say this? But actually, we do. And the majority of the recommendations, pretty much, there's maybe a handful of very, very technical ones, all fell under at least one of these principles. And just with the rest of my time, and this is really taken from the way in which the white paper was developed, are kind of 10 key areas of focus. One is around clearer, stronger detention criteria. If you're going to detain me, make sure that you are doing it lawfully and that it's appropriate. Patients' increased rates to challenge detention. If you are going to detain me, I should be able to really regularly have that reviewed, and you know, if appropriate, to be discharged. Simon's already mentioned this, to strengthening the patient's right to choose and refuse treatment. Again, you know, about a 50-50 split of people that said, no, I should never have been detained, and then those people that said, yeah, it was the right thing for me to be detained. But actually, regardless of that view, the ability to be able to choose what happens to you is massively important. As is issues around nominated person. Again, you know, a consequence of birth around who your parents are, for example, should not then automatically lead to them having a say over your care. CTOs, we could have a whole philosophical debate about those on their own. Hopefully we will at some point, because they are massively overused, in particular for Black communities. Simon's already mentioned the interface between the Mental Health Act and the Mental Capacity Act. I still don't understand it. And I'm going to go slightly over. I'll fight anybody that tries to stop me. Caring for patients in the criminal justice system. It's what on the way down on the train, I sat here and I really spent a lot of time looking at this slide, because it is a statement on our society, really, that not only are there such numbers of people that find themselves in the criminal justice system, but the fact that so many of them have had, quite frankly, awful life experiences and have quite severe mental health issues that we don't provide proper care for them. And again, we were constrained in some way, but really did try to understand what are the barriers to providing the right care for these individuals. Simon has mentioned and touching about the need to make sure that people who have a learning disability and or autism are not detained because of that fact. You must have a mental illness and be in crisis to be detained. Children and young people, again, it's a really tricky area, but we have to make sure that we balance the rights of the parents with the rights of the children. And again, I cannot do justice to this, but really the patient and care race equality framework, which clearly didn't go far enough for some people. Some people really wanted us to make the point around institutional racism. We did, but you don't change racism by shouting at people and saying to stop being racist. It's a phenomenally complex issue. The last 18 months have told us that, and this is a step in the right direction. But it's not what's written in that report, and it's not just on the government. It's what we all do, and we all have a role to play. Simon has talked about some of the different actors, legal people, people that work in hospitals, people that work in the third sector, and it's really about what we do. I've stolen 2 minutes off somebody, so I owe you that. But thank you very much for giving me the time to talk today.
Thank you. Only the depths of time that people had for me when I knew how to catch them in. Have you so rich?
Yes.
No, thank you. That was really fantastic. So our next speaker is Professor Judy Lang, who is a professor of mental health law and policy at the University of Bristol Law School. Her research interests are in mental health law, policy and human rights, and she's a co-investigator on a project entitled Balancing Best Interests in Healthcare, Ethics and Law. She's also undertaking a parliamentary academic fellowship in House of Commons library related to mental health law and policy reform. Over to you, Judy.
Thank you very much. I shall just get my slides at the ready. Lovely. Well, thank you for that very kind introduction, and also for the invitation to speak today and to join this very distinguished panel, actually, especially the likes of Steve and Simon, who are actually directly involved with the reform process. I haven't been directly involved with the reform process. I'm an outsider looking in, so I can be as critical and as positive about the reforms as I would like to be. But generally, what I'm going to do is, in 8 minutes, or have I got 10 as well? Okay, I'll try my best. I have to tell you though, I am renowned for running over in my lectures and my papers, so I'll do my best to try and keep it short. So onwards and upwards. I thought I'd focus on, I guess, human rights, although I think I should be calling it choice in the current climate. And actually, what you said, Simon, will now explain something I'm going to say later on in my slides about human rights and how they don't really appear at all in anything that the government has produced in the wake of this reform process. But why am I focusing on human rights? I mean, I guess it goes without saying they've been a key driver really in the reform process, certainly at least in the report that your team wrote, Simon, and they really are important when we're looking at mental health care. Larry Gostin, who was a key driver in the reform process even before Ginevra, a US scholar who's written a lot on mental health law, but also on public health law and rights, talks about human rights law being a powerful tool to advance the rights of persons with mental disabilities and the fact that they're mutually reinforcing. So that's the kind of framework I thought I'd look at today as a lawyer, because a lot of the frameworks and standards in human rights legislation will really kind of reflect the legal principles that we'd like to see in our system in terms of the rule of law, equality, justice and due process. So the law has to be compatible with the Human Rights Act, and there's certain rights I think that are particularly relevant for us today when we're looking at the mental health law. In particular, the right to liberty, Article 5, Article 14, the right to be free from discrimination, Article 8, right to private and family life, Article 3, right to be free from torture and human degrading treatment, and particularly as well, we need to balance some of those rights with the right to life. And there's quite a lot of case law in this particular area related to the Mental Health Act, which relates to a number of those articles in relation to the European Convention. When we talk about human rights, they were a key driver, I think, in the reform process, at least in the rhetoric of the early stages when we had the independent reviews report. they're noticeably absent from the white paper and in particular the government response, although now I see why choice is so prominent. I think when we're looking at the principal aim of the reform, you're right, it's about redressing the balance. But I would say not just between patients and professionals, but also between paternalism, autonomy and public protection, because we also make decisions on the basis of the health and welfare of the individual, the health and safety of the individual, not just the fact that they're a risk or to the health and safety of others. So I think we're trying to balance those three principles when we look at mental health law. I mean, primarily what we should be doing is promoting the health of the individual, but there are those other factors that we have to consider. And how different mental health laws balance those has varied quite considerably. And I think a lot of the driver has been the socio-political context. And I think for me, that is quite key in terms of where we're going now with the reforms in the future. There's certainly a strong rhetorical commitment to bolster the service user voice and choice by promoting autonomy and choice. But I think overall what we see, and I think your review did an amazing job, Simon, and I don't want to be critical of your review because we're sitting on the same panel, but I'm a lawyer, and there's always room for improvement. And I think you focus very much on the Human Rights Act because obviously it's directly enforceable, and it's the language that politicians, albeit framed as choice, understand. But there are other rights as well, I think, that should be considered, and in particular a lot of pressure now to look at the United Nations Convention on the Rights of Persons with Disabilities, which was, I think, effectively sidestepped. Although I will say that the approach you took to involve people with lived experience, as you'd said, Steve, so centrally in the process is a key aspect of the approach that the CRPD would endorse. So what we see, I think, is a kind of attempt at modest and quite pragmatic reforms, I think, in terms of achieving the best compromise that you can in the current climate. Whether it will actually achieve that remains to be seen, of course, because the devil will be in the detail of the bill if it eventually appears. So what we've got is, I think, an essential framework that's been around for quite some time, really, that remains intact, with the focus on compulsory admission, compulsory treatment, a diagnosis of mental disorder, that's the pathway, and the exercise of professional discretion is very strong still in the process, albeit tempered a little bit by some of the safeguards. So why did the CRPD, and I can't see why it's not whizzing to the next slide. Oh, it seems to have stuck. Is that all right? Am I allowed an extra 10 seconds, sorry, Freudian slip there, to allow for a slide? Is that okay? Yeah, okay. So what did the independent review say? That's it, that one, about the CRPD. I think whilst you agree with the positive vision, you don't share all the goals, particularly of the committee and the way that it's interpreted. I mean, there are other interpretations of the convention available, but I guess we have to be guided by the committee. And the European courts and various other UN treaty bodies don't believe in that either, because I think the logical conclusion of the CRPD would mean that we need to abolish mental health law in order to comply with the provisions. And of course, that's not the approach that's been taken. And the feeling is that the committee's interpretation goes too far. But the CRPD is an aspirational treaty. It's not directly enforceable in the same way the ECHR is, and it's kind of, you know, a ceiling, not the floor that the ECHR is. So what we want to try and do is perhaps get somewhere in between those two, I think, if we want to really bring about meaningful reform, because the ECHR provides only the minimum protections. So what does the government think about the CRPD? Well, I found a quote from the Minister for Disabled People for Health and Work in the House of Commons debates in June, making the most of my library access in the House of Commons at the moment. The government are utterly committed to the convention, we are told, and Britain helped to develop and shape it. But the white paper actually doesn't really mention the word rights, let alone the word CRPD, and it's certainly not present at all in the consultation. So I think we've got to sort of park the CRPD, because that's another one that we could talk for hours about, I think. But I think we need to bear it in mind in terms of some of the sort of, I guess, aspirations within the CRPD for a very different approach to positive rights and entitlements. So a quick kind of health check of the proposals, and by these proposals I'm talking about the government's white paper proposals and the response to the consultation rather than the review, because there are some differences between those proposals. And I'm putting these proposals around these articles very much related to the principles that you've described already, Steve. So the principle of least restriction, I guess, would relate to the Article 5 right to liberty, and not to be deprived unlawfully of our liberty. Various conditions need to be attached to that. And we see some revised admissions criteria, which rightfully shift the risk threshold a bit higher, but of course there are still problems with with risk prediction. But what concerned me a little bit in relation to the criteria and is the fact that the concept of welfare has been slotted in, and that it's not just that admission is going to be for the health and safety, but it's also for the welfare of the individual. And I think, you know, we see welfare being used in other areas to make paternalistic decisions on behalf of individuals, and there is an issue around definition that we need to think about. So I'm going to sort of probably ask more questions than I answer at the moment, but these are just sort of what struck me as a lawyer and somebody who's advocating for human rights as troubling about the proposals. Again, community treatment orders, you've already mentioned these, Steve, but from the point of view of the kind of liberty, right to liberty, you know, there is, and it's acknowledged, a lack of evidence base about the efficacy, and I think there's a concern around the sort of time limits, whether we're going to have a time limit with a CTO or not, because the worry is that people are left on CTOs for far too long, as well as them being used inappropriately, particularly for some communities. Welcome enhanced powers for the tribunal. You know, the review team recommended this, the government supported this, but of course Article 5.4 does require a speedy review of detention, and I would question, with the increased workload and all these extra rights that are being given, that we might see that being compromised in some way if the sort of resources don't follow. I'm quite concerned about the role of the CQC and complaints, particularly in terms of direction of travel with the Health and Social Care Bill and the remit of the CQC expanding, how it's going to really be able to keep an eye on these sort of deprivations of liberty and people who are detained under the Mental Health Act. And I think there's still a risk of longer term detention for people with learning disability and autism in the proposals, as we can see with Section 3 being still available in exceptional cases. Potential for discrimination, I think, does still exist. The differential treatment of civil and criminal patients based on the unique risk profile, I think, can create arbitrary distinctions. Again, you know, there's scope for the situation in Wales to be slightly different, and I think that does raise questions if we look at patients when they're being moved across from one jurisdiction to the next, how that will work out. And I am concerned a bit as well about the treatment of young people and adolescents, and how the proposals don't really address some of the challenges around the legal frameworks there. I am going to run over as well, I'm afraid. So I'm afraid, Gareth, you might end up with about 5 minutes by the time that we've finished. But I hope I'll try not to sort of speak too long about this. But Article 8, I mean, this obviously typifies the sort of autonomy and choice principle, and we do need to recognise that it's a qualified right that needs to be balanced against, for example, the right to life. But I'm quite concerned about aspects of the enforceability of the statutory care plan, the pressure on the SOAD system in relation to refusals of treatment. How is urgent treatment going to be defined? Advanced choice documents, you know, again, really, I can see the government supporting this, but there are question marks about them. I know you've written about them, Gareth. I've read your piece on them. But, you know, looking at some of the uptake on advanced decisions to refuse treatment at the moment, only 2% of people in Wales and 4% of the population in England in some research in 2016 had actually thought about this. So I think we're going to have to really make sure that these are implemented adequately if they're going to be a meaningful right, and Article 8. I think there's also question marks about advocacy and nominated persons. Again, there's stronger safeguards to help somebody to exercise autonomy and choice, but there are question marks about how they are going to be fleshed out, I think. And finally, Article 3, inhuman and degrading treatment. I do worry about this because of the Care Quality Commission having an expanded role. It's got a role as a preventative monitor under OPCAT, and I'm a bit concerned that mental health it has been marginalised in the CQC's monitoring work. The Mental Health Act annual report gets smaller and smaller every year, and I don't think the problems with the Mental Health Act implementation get smaller and smaller every year. So some concluding thoughts, and I realise I have even run over your time, Steve, but I can pick these up in the discussion with you. There's going to be a heavy reliance on the code of practice. The government says in its consultation responses, lots of things are going to be worked out in the code of practice, and that does worry me when we look at how little the code of practice does influence practice already and how knowledge of the code of practice is poor. I think the current model will perpetuise the kind of binary approach that we have, which is very medicalised, and I think if you have a look at the approach in the Scottish Mental Health Act review, it's taking a very different and more aspirational approach to the reforms. And I think there's some areas that need to be worked through. We need to embed the principles beyond the legislation. And I think what worries me more than anything is the political climate. I can pick this up in the discussion. This is all subject, isn't it, to future funding decisions, subject to the impact of the COVID, subject to affordability, and legal reform is only coming when parliamentary time allows. That's not shown me that mental health law and rights and choice is a priority moving forward. And I'm sorry, I have run over 3 minutes, but I do apologise.
Yeah.
Okay, thank you very much.
Thank you very much. So, our final speaker is Dr. Gareth Owen, who's a reader at King's College London and honorary consultant psychiatrist at the Maudsley Hospital. His research was focused on decision-making capacity and related areas, spanning theoretical to practical issues as well as policy impact. He's also founding member and trustee of the Maudsley Philosophy Group charity, and he happens to be deeply committed to setting an example of how to keep to their time limit.
Very good. Good. Well, thanks for the invitation, and I guess for the opportunity to sort of pause a bit, step back, and reflect on where we're at. What I'm going to do actually is pan right out. I mean, with respect, Simon, the Mental Health Act that you've looked at is in one jurisdiction. There are 4 in the UK, and we're one country amongst many. And this is an international phenomenon, and there are many examples historically, and there will be many more ahead of us. So what I'm going to do is just think about the concepts of a Mental Health Act, and hopefully this will stimulate some discussion. So history always helps, and if we take a big picture here, I mean, really there are 2 streams of health law, and for various historical reasons, they've tended to apply to 2 categories or types of people, so-called medical patients on the one hand and psychiatric patients on the other. So with medical patients, there have been legal discussions of consent, which are very old. In fact, I was giving a talk in Dublin recently, and they most definitely go back to Jonathan Swift, and Swift, in fact, helped set up a hospital in Dublin. So these are old discussions, and this is the common law of capacity and consent. So the surgeon takes consent and is meant to consider capacity when they're considering an intervention for a patient. Psychiatric patients, on the other hand, have tended to have, at least in the context of severe mental illness, a very different approach. And so the first piece of mental health law really in this country, the Lunacy Act, 1845, was really about regulating the asylums. That was the function of the law. And that law has evolved over the years. There have been various changes, but really the Mental Health Act 1983 that we have, is in that. It has that lineage. And these 2 streams, as it were, of health law haven't talked to each other much historically. And it is giving rise to really rather interesting but complicated predicament. So if we look at the English context or predicament, we have now the common law of consent capacity codified very neatly into the Mental Capacity Act 2005. And we have the Mental Health Act 1983. Now, what's happened really is that these 2 pieces of statute can both apply to the same person. And this is the person with mental disorder or disability broadly defined. Now, it's even more complicated still because there's the human rights context. So domestically, we have the European Convention on Human Rights, which is in our law through the Human Rights Act. So that's a regional convention or instrument. But we also at the international plane have this, and it's been mentioned by Julie, the United Nations Convention on the Rights of Persons with Disabilities. Now that's not incorporated into our domestic law, but it's there. And there are conflicts actually, or differences, significant differences between those two human rights instruments. So the person with mental disorder or disability is actually sitting within this complexity legally. And it's, something which is, gives pause for consideration, particularly when ultimately, at the end of the day, images are more important than anything. And we've got these histories which are very, which are carried forward. So the metaphor of the knot comes to mind, and I think it is a knot. I mean, knots can be interesting or very interesting or infuriating, depending on how you look at them. So we have a knot, and the question is it a Gordian knot? So what's a Gordian knot? Gordian knots are knots which reflect complex problems which afford bold solutions. So this comes from, of course, the famous story of Alexander the Great. So Alexander the Great, return of one of his great trips, came upon a chariot. It was tied up with a knot. Everybody was trying to untie the knot. He came, cut through it. Bold solution to a knot or to a complex problem. Now, this is an area where there are quite a lot of bold solutions around, basically, to complex problems. And what we did here at King's, this was a partnership with the King's Policy Institute, right at the time, pretty much when Theresa May announced, really pretty much unexpected, actually, that there was going to be a reform of the Mental Health Act, is that we assembled a so-called policy lab to try to kind of, as it were, map out the conceptual space for Mental Health Act law reform. Now, this is one way of doing it, and we found it helpful. So to think of a matrix, basically, with two axes. So the x-axis here is an axis of autonomy. Okay, so it's really reflecting in relation to the whole project of compulsory treatment for mental disorder. To what extent are you going to value individual autonomy? So if you go up, you're going to try and value it a lot. If you go down, you're not going to value it. We consider that there are other values in play. The other axis, which is going along the horizontal axis here, is about whether, in fact, really this is an area where you want legal rules at all. Okay, so this is whether or not, on the one hand, you're going to have formality. Okay, so if you move in the direction of the right, you're going to have rules. Okay, to regulate this. And if you go in the direction of the left, you're going to have very few rules, perhaps no rules, actually. So that creates 4 cells. And so if we go through them, we can actually think of instances where this approach applies. So cell A is where you're going to prioritize autonomy, but you don't want rules in relation to, you don't think there should be legal rules that regulate compulsory treatment. Now, this is really the position of the Committee on the UN Convention on the Rights of Persons with Disabilities. It was certainly the position of its General Comment 1. And here the view really is that states should abolish mental health laws for compulsory treatment. Really all intervention should be based on the will and preferences of the person with disability. So this is really an abolitionist movement. Here you're trying to get rid of the very idea of a Mental Health Act. So B is where you're trying to value autonomy, but you think that the compulsory treatment for mental disorder should be regulated. There should be rules. Now, the best example of this actually is nearby. It's in Northern Ireland, and the Northern Irish now have enacted a law which is based on the notion of mental capacity. So this is a capacity-based law entirely. It's sometimes called a fusion law. So really the Mental Health Act here has been transformed into a kind of expanded version of the Mental Capacity Act, and it applies to medical treatment decision-making, equally to to mental health treatment decision making. So that's an example of that. Now, C is where you don't want legal rules, but you're not really necessarily valuing autonomy. Now, here again, there are instances. So Iceland apparently has a law which puts an enormous emphasis actually on doctors' discretion. Of course, many countries around the world, low-income countries, won't have any mental health law. So here, doctors, because they exist and they have to manage situations with severe mental illness where notions of coercion may arise, are broadly accepted as having the authority and the discretion to make decisions with or without consent. And that's colloquially, you might think of that as the doctor knows best sort of approach. D would be essentially where we are now, actually. This is where we're not putting much emphasis on individual autonomy, but there are a lot of rules. So the Mental Health Act 2007 here in England amended the Mental Health Act 83, and it introduced basically lots of rules, lots of legal rules. We won't go into the details of that. So this is really a kind of conceptual space for Mental Health Act law reform. Now, we took the view on this, like, well, what came out of the explorations in this lab is that in England, we're pretty committed to there being rules, basically. And so that means we're kind of on the right-hand side here of the diagram, but that we're trying to move in this direction. So from D to B, we're trying to move in the direction of putting more value in the area of severe mental illness on individual autonomy. So now that then introduces what's been talked about before, is the interface between the Mental Health Act and the Mental Capacity Act. Now this is a knot, it's another knot. And it's in a way not surprising it's a knot, because here you're getting at, very deep philosophical questions. The tension between personal and public interests, between about the very nature of autonomy, continuity and discontinuity of personal identity when you're trying to think of advanced decision making and so forth. I mean, these are difficult problems. So I think what I want to just leave with is the thought that when you're trying to unravel a complex knot like this, bold solutions are perhaps not the best approach, and that progress is going to be made less by bold solutions or quick action, and more by sustained interdisciplinary. It has to be, for the reasons that have already been discussed, interdisciplinary learning, cross-agency working, and very importantly, resourcing. I mean, this is an area where it's very difficult to make progress at all unless you can guarantee resources. And it's, a lot of questions, I think, around this right now. And Simon and his team, given the political options, they weren't able to kind of, bring into existence a money tree, basically. I mean, that wasn't something that you were going to be able to do. But resourcing is a huge background consideration here. So this is just a quote about the future from a political theorist, which I think just helps us with this task of getting the balance. I don't know if I'm on time or not.
No, you're not. Well, you're only 1 minute over, so you do win the prize,
okay.
Gareth.
1 minute over.
And I definitely don't.
Okay, so I'm just bringing forward our 4 minutes comfort break. Stop making this noise. I'm just bringing forward a 2 minute comfort break. So we'll just have a moment to stand up, stretch. People at home grab a glass of water. I'm going to make a cup of tea, and then in 4 minutes at 6:15, we'll be back. Okay. So welcome back, everyone. I hope everybody has done whatever they needed to do. I made myself a cup of tea. And the panel here is rearing to go, very difficult actually to stop from already talking about the issues. So what we'll do is we'll have 10 minutes of kind of free talk within the panel, on which I will try and keep some sort of steer. And then we'll have Q&A from the audience. If you want to start putting Q&A in the questions, put questions in the chat or put a Q in the chat, and then I can give the word to you. Feel free to start. But I know that Steve wanted to kick off. So off you go.
Not literally.
Metaphorically, but I must say literally. I think it was
No, I'm gonna throw another spanner in the works slightly, because there is something very much around all the arguments being really valid, but actually, when you speak to people that have been detained and you speak to everybody involved, overwhelmingly, not in all cases, but overwhelmingly, something could have been done different in advance of that. And I think that is the real crying shame, is that actually we were in a position where we had to have, this work had to be done, but actually it's almost addressing the wrong question. And I don't want to get into a conversation around community mental health care, because that again is tremendously difficult. But when you have people who are known to services, who their family, their friends, they know quite often that they're unwell, I really question why we don't do a better job of heading that off.
I mean, I think that's a very valid point, because I think the nature of this mental health act is it's a reactive kind of framework that's in place as the kind of end point. And that's when the law comes in, isn't it? To sort of say, right, this is what's going to happen to you. Whereas actually what we need to do is think about bringing that forward. And that's, I think, and I don't want to bring the CRPD in too early, but that's where the CRPD tries to create this sort of entitlements and the focus on, prevention, intervention, early intervention, when you have those supports and systems legally in place earlier in the process. But yeah, because otherwise you're then left with the Mental Health Act somewhere down the line when everything else has failed.
Yeah, and just to curtail a very long conversation, if we removed the Act or any of the provisions, I would be incredibly concerned. I mean, as things stand today, I've initiated the process of getting a prototherapist, and that's as things stand, and that's as somebody that has lived with this for many years and will live with this until there's some kind of major development around managing bipolar disorder, for example, that I'm going to have to fund that myself because I want to have the best protections. That's not a slight on the NHS, but I'm in a situation where I see my psychiatrist once every 18 months for 5 minutes. That's not good enough. So again, that question of, is the UNCRPD the right way? I don't disagree with some of what's said in there. I think the interpretation is tricky. And that's not a conversation about resources as in what's in this budget, but it is fundamentally around how our society views the mind and how it really prioritizes the well-being. Because if you get it right at the far end, actually we can get it right, for the majority of people. But yeah, phenomenally complex. Hence the nod.
Can I
Not.
There's a question as a nod. Yeah, it should be stated. Not sure if clearly nods in view. Can I read out a question from the chat? I think it's interesting. It's a question from John Mason, who asks why it's reasonable to determine mental health status in Section 3 using nature, using a patient's history. So John says it's not acceptable in other methods of law to restrict people based on their nature or history, and it would be seen as unacceptably discrimination normally. So why does the Mental Health Act use history, and shouldn't they instead base their decisions on degree, which more fairly refutes what's happening now without the prejudice of considering the past? So effectively asking about whether you should make your decision stripping out knowledge of the history. I think that's what it.
I've never had that question before.
Me neither. I thought it's an interesting one.
Well, I think they're actually asking what. I think they're making it. It's a fun, slightly misunderstanding what medicine, not even what psychiatry does. It's what medicine does. A world in which doctors don't take histories. I don't mean it in the proper way the historians do, in the rather pathetic and abbreviated way that we do. But nevertheless, we're always taught 98% of medicine is based on the history and 2% is on examination. That's probably true. I think a world in which we didn't do that would be, I'm not entirely sure what it would be. It would be more like a lottery. I can't quite get my head around that idea you make a fundamental decision based on your assessment of someone's mental health without knowing their history.
Does that
the
not feed
short
into the sort
route
of
to a
risk
GMC.
assessment, though, in terms of
Yeah,
the, you know,
you'd have to.
when you're depriving somebody of their liberty based on the presence of their mental disorder plus the risk of them being a risk
Yeah.
to themselves or others, one of the predictors of that risk is evidence of past behavior, isn't it? And it
It's a
is.
much better answer than
Is
I
that
just
is that
gave.
what we're trying to say?
I
Yeah,
think it is,
I
yeah.
think that's probably why I'm not a clinician, so I don't undertake those risk assessments, but I do know that is one of the sort of indicators, isn't it, I guess, when you're taking somebody's history, and if they've attempted suicide and demonstrated that in the past, then it may be that they're more likely to do so again. Would that be a...
Yeah, I mean, there are 1,000 things to detect from
Yeah,
history.
it's
will
not just
become
that.
important.
Yeah.
It's not just that. That's a pretty good example. Yeah.
Can I ask a neat question about it? Is this related though to the point you raised, Gareth? So if they get the Mental Capacity Act, kind of make an in the moment, make an in the moment judgment of somebody's capacity that isn't referencing history, but just look at their capacity in the here and now. Whereas in the Mental Health Act, you do take history into account.
Well, I mean, I think yes and no. So when you're assessing capacity, the assessment of capacity can and indeed should draw on history for all the reasons Simon gives. But the notion of capacity is that it's asking the question: can a person make a decision, let's say about medical treatment, at the relevant time? So that's, you know, that could be now. Okay. So so that's a test which is very time specific. So whereas in the Mental Health Act, the approach is rather different. So it's asking really, does the person have a mental disorder of a nature or degree? Okay, that's what it's asking. And then it's asking the risk question. So on that, you may really very much be very influenced by historical factors and potentially not very influenced by factors, you know, relating to how the person is in front of you now. And that can be controversial because you might be dealing with somebody who appears to be very, I mean, this comes up in tribunals, you know, debates in tribunals where somebody is seemingly very well now, and the team are arguing that, you know, the case for detention remains because of historical factors, and, you know, clinicians can argue that out in a tribunal, and that may be to do with what's, you know, certain patterns that have been well established around, you know, let's say non-compliance with medication, and then in the context of non-compliance, worsening or deterioration of mental state, and then, you know, people might then draw on a risk analysis of historical events and so forth. So these things can get argued out, you know, in tribunals where there isn't, because of the way the Mental Health Act is structured, you know, there isn't a discussion about, okay, well, does the person at the moment have a capacity to make these decisions for themselves? You know, that's not really kind of entering into the discussion. So that, I mean, that may be part of what we're discussing here.
But I think what's interesting is, and I'm very much on the patient side, is the history is very specific. So I've got all of my medical notes. I've got all my medical notes back to when I was born. Big stuff. And the bit over the last 10 years around my mental health is one-sided. I don't get to record anything. So on that term around medication, for example, it's very rarely recorded, or even if it is, it's recorded in a very specific way. Person doesn't like the medication. But actually, we didn't really get into kind of why. And actually, you know, if there's a medication that is, you know, severely affecting your energy levels, or is affecting your, you know, your sex drive, or is giving you restless leg syndrome, or whatever it is, actually, it's really reasonable that that person says, I don't want that. I think fundamentally, and again, big philosophical question here, and I'm not saying that any one person is making this assumption, but when you look at all of the evidence, there's an assumption that people don't want to be well, which I think is wrong. And I think if we come at all healthcare, which we do, except here, that people want to be well, I think we'd be having a different conversation, because I think that conversation is actually, you know, does that person really want to be, you know, a harm to themselves or to anybody else? In the large majority of cases, no. So actually, what is it we need to put in place that actually promotes that person's sense of being, that keeps them safe, you know, rather than, and you know, I'm a very good patient, but partly that's because I didn't push back at times. And you know, what's interesting again is we talk about this in the framework of the Mental Health Act, and that's detention. We never really talk about the fact that there is clearly coercion in the community. So actually, you know, there is very limited support offer. If you kind of push outside of that and you kind of demand a bit more, and again, you know, sweeping generalization, there are pockets of really good practice, but actually, you know, the things that were offered to me were very, very limited. So I took the things that were there and kind of filled in the rest as I could. But actually, you know, there isn't nearly enough provision of difference. And again, you know, there is a real acknowledgement in the review and in the work since to provide alternatives. But actually all of that's feeding into the history. And I think that the concern for me is if that history, it's how it's viewed, and is there a prejudice there to actually this person's become violent? Well, actually, do you know what? Just because that person has been violent or was presented in a certain way, actually, we should really try to kind of to be informed, but not led by that, which is massively, massively challenging. I'm not sure what I just said there, actually, but it's what happens when you invite me to talk about philosophy.
There's a comment in the chat that's certainly backing up the need for more investment in, you know, not having a mental health act be necessary because you take care of people better in Europe. It's like a crude rendering of it.
Throughout the whole,
backing up of that.
I mean, throughout the whole process, every time we did public engagement, I always had the same statement that, you know, 80% of what people are wanting is nothing to do with the Mental Health Act, and the Mental Health Act doesn't create better services. It's not intended to create better services, actually. Maybe 20% of what people are wanting was actually related to the Act, and 80% of improvement will come through better investment in alternatives to detention, early interventions, which obviously are not in the purview of the Act. It was in fact it was the 10-year forward view that was supposed to take care of all that, and did, but hasn't been funded.
I mean, yeah, and the worrying thing is, of course, that, you know, there was the evidence that was given to the, I think, the scrutiny of the Mental Health Act 2007 reforms. And I think there's a quote in there that they took evidence, and it's like one of the professionals they spoke to said, oh, you know, using the Mental Health Act is the ticket to getting a hospital bed, I quote.
Yes,
and I think there was a perception, and I don't think the evidence, so the CQC looked into this and they couldn't really come up with a definitive answer, but there was a feeling that the Mental Health Act at that time was the way to get access to services for some people, some patients.
Some junior doctors have been saying on Twitter when there were no beds anywhere in the country, the only way to get them. I think in really desperate circumstances that might have some truth, but it's also illegal, by the way, to do that.
Of course it is.
But it was difficult to substantiate that was a major factor. But I mean, somebody said that on Twitter.
It is an interesting thought experiment, because it's a philosophy session about whether or not, you know, the Mental Health Act and structures like it are going to kind of fade away over time. You know, well-resourced systems, you know, continuing to kind of grow materially.
This is utopia, isn't it?
Yeah. So, you know, resource slowly increasing, you know, and sort of more preventative treatments come in, and so forth. The Mental Health Act sort of fades away, it melts away over time. I mean, what do you think, Steve? I mean, you know, what's the experience of bipolar? You know, it's more complicated than that, isn't it? Or, I mean, the Mental Health Act is, you know, it's applying to a wide variety of circumstances, including dementia. And we're not expecting dementia to fade away, are we? I mean, that's just kind of not what we're expecting. So it's...
I want to go there, to Gareth Land, where that is the case. there will always be a need for the Mental Health Act, because I think that even if we had the best mental health care in the world, the best social care, and that you would still have a small group of people, of which or any of us could find ourselves in that really small percentage where
Absolutely.
it's just, there is a configuration of everything that means you need that hospital care. But if we massively reduce, actually, that inpatient care could work really well. I wouldn't have got my diagnosis of bipolar disorder if I wasn't detained. So I always have a really weird relationship with this, because one of the things around bipolar disorder is, guess what? When you are high, you don't go to the doctor. And even when you're depressed and your friends there with you and they go, oh, they also have highs, the doctor can't see it. And, I thought it was great that I was, all powerful and omnipotent. And, that's not viewed as illness. So actually, again, part of that, section 2 is for observation and initial treatment. Box ticked. I think the issue comes when you've got people that are spending years in hospital and you're going, there's something wrong with the model here. And that is, I want to kind of bring this back. And I think that, again, we really tried to sit with this during the review, and it was incredibly difficult. And I'm not going to speak on Simon's behalf, but I know that, I was massively challenged by this, is the human cost. You are forcibly taking people from everything they know. And you're restricting the times in which they can see the people that they love and the people that are in their lives. If there was a mental health act that somehow managed to keep people in touch with their lives better, that allowed them to work to some degree, that they didn't lose touch of everything, I think that would be different. So again, it's not even just around should there be a law or not. It's about actually, what is the purpose of it, and what purpose does it serve to take people away from everything? There should be iPads in every single hospital that are freely available to allow people to keep in contact with people. We're the whole world. We're doing this right now on Zoom.
There's a question that I think relates to this from the audience, from Phoebe Gold, who asks, how can we prevent re-traumatization by the use of restraints? And are there changes to the restrictions and treatment criteria that will address this?
There we had running parallel with its Senny's law. So we didn't really tackle that because they were about 2 years ahead of us. And in fact, the law came into being, was enacted whilst we were still working when it went to the launch. So Senny's law was specifically about that, and
it came into force recently.
The Mental Health Unit's Use of Force Act 2019, which Senny's law, the statutory guidance was published and it came into force just before Christmas, which provides a mechanism for sort of oversight and accountability for the use of force. But it's interesting, isn't it, that the use of restricted practices are not regulated directly by the Act. They're in, it's all in the Code of Practice. All the guidance around use of force and restricted practices. And again, if you look at the CQC reports, they constantly pick up on this and concerns about that, as does the Committee on the Prevention of Torture when they've been here, the use of long-term segregation and all those kind of strategies which are often adopted. And I think, just picking up on your point though, Steve, I'm just trying to think, I was about to say something when you were talking a minute ago, but that's the problem, isn't it? We perhaps do need that legislation in those periods of acute crisis, but for short term, not people languishing there, because then there's issues around aftercare and support on aftercare and discharge, etc. And I also wanted to pick up on another point, which I think it's just escaped me as I was going through, as I was thinking what to say to you there. But the problem is we don't have that system at the moment, do we? We have that system where people have been detained in hospital for long periods of time, and actually it's the process, isn't it? I've done some research recently, and I know your review, you looked at the role of the sort of relatives in supporting patients who are detained, and I did some research with what they call nearest relatives at the moment, although potentially will become the nominated person. And virtually every person I spoke to talked about the whole traumatic process of the detention process. The police were involved, coming to the house in a lot of cases. And, that may be because there was, concerns around personal safety for relatives, but it may be because the ambulance couldn't come. It may be because there was just no other way of getting this person to hospital, and that process is incredibly traumatic for everybody, not just the individual, but for the family, who are then left at home without support. And it's about thinking about that wider context as well, I think, and the impact on I don't know, if that's something
we did look at that in detail. And the police come because the police are the ones who answer the calls. And again, that's what happens, and ambulances don't. And we're certainly not on the Christmas card list of the ambulance service, because we said that should be reversed. And the first attender should be the ambulance, and only according to the work in West Midlands, I think it was East Midlands, it was somewhere in the Midlands, only 10% of calls actually there are calls that do require police, and we wouldn't in any way doubt that, but it's about 10%. So we did say it should be 90% ambulance, and statutorily the ambulance should be the first people called. And they what a surprise, the ambulance, whatever their authority is called, did not accept that recommendation, but the government have. So I have to see what happens next.
They've got a lot of work to do on ambulance waiting times, though.
Well, yes,
haven't they? I think, people with heart attacks can't even get one at the moment.
True. That is absolutely true. But yes, nevertheless.
This is funding, whether it's iPads or ambulances, always come back, don't they? And there's a comment of somebody saying some issues also come from when people are admitted, where people are admitted to, so to be taken really far away from their family. And here's which I'm sure you can just leave there as a comment. And there's a question that somebody says, I was wondering if anyone could say a little bit more about something Professor Lang spoke about, which is the contrast between a medicalized binary, quote, in the England Mental Health Act, and a more aspirational approach, and quoting you in the Scottish Review. I was particularly wondering how it relates to Dr. Owen's dimensional taxonomy of approaches.
I'll start that one off. Sorry.
No, please do. Please do.
Go for it.
There was an assumption, because I'm a psychiatrist, we would follow the dreaded medical model, which is always used as an abusive term, but actually when you look at what the medical model is, it's a perfectly good thing. And that from the social work community, that we would somehow reduce the importance put on the social side. And we had absolutely zero intention of doing that. And indeed, the balance between the social, as exemplified by the importance of the pre-social worker and the psychiatrist, remains fundamental to the way the English Mental Health Act and Welsh Mental Health Act operate. And there was never any intention whatsoever to change that in the slightest. And I don't think there ever should be. So it will always be, but there is those two aspects are both there. They balance each other quite nicely, and you need both.
Do you want to say something about?
Yeah, and I guess you've also got the third dimension, which is the role of the expert family sort of carer view to balance that at the admission, isn't it? Yeah, and I think what I was saying by that is that we've still got the you're mentally disordered or you're not as the kind of gateway, haven't you? For this, which doesn't take into account capacity. And I think I'd had a look at the interim report. I think you've spoken to the Scottish review team, haven't you, Gareth? Have you been to speak to them? You might know a bit more about it. I've just read their report and I know a couple of people on it, but they're looking at a sort of more CRPD view, I think, of reforming their legislation, and certainly they're engaging very actively with it, and perhaps going down the model perhaps a bit more akin to the fusion model, I think, in terms of their direction of travel. They haven't made their final recommendations yet, but my understanding is that they want to change the gateway really for making treatment decisions. And I don't know if you've got more intel on that, Gareth.
Well, I was going to come back to the point Simon made, actually, which I think is which actually is often not fully appreciated about the Mental Health Act 1983, which is that, people think of it as medical, but when you're assessing somebody under the Mental Health Act, you have to have two independent doctors, and then there's the AMP, which is somebody really coming from a social work background. Now, the person who's really got power is the social worker.
Oh God,
actually,
yes.
because they hold a trump card on the process. And what's more, doctors got to rush in and sort of try and do the paperwork, quickly. Social workers got 14 days to mull it over, basically, to say up or down. So the role of the social worker, or that perspective in the assessment process in the Mental Health Act is is pretty striking, actually. And I was interested that you preserved that, because that was really that was introduced by Goston, wasn't it?
It was, yeah, no, in the 1983.
So you made a call there, Simon.
You had a lot of calls, Gareth. A lot of calls. But
I mean, you could have returned it all to the doctor.
BSA SW, the social workers did think we would do that. But from right at the start, we just said, we're not going to, by the way, if you're thinking that is not on the table, let's move on.
No, that is, and it's interesting. Jill PA did some interesting research looking Decisions and Dilemmas, I think a book's called, and it's about, she did vignettes, I think, with social workers and psychiatrists to see how that kind of process of decision making of an admission, would you admit this person or not, do you think, and how that dynamic works amongst those professions. I don't know what your experience is, Steve, you know, on the other side of it all.
Well, again, I think some of the fringe conversations were, you've got all these people involved. If only there was a mechanism for them being involved days or weeks before that, were actually, and I know that, you know, and again, it's a reconfiguration as much as a resourcing issue, because actually it's almost like nothing. We need to act, and there is I think that's what's quite sad, actually, is that those people are all there, so it's not as if they're not there. And then we convene them in dramatic fashion. I mean, I remember the first time I had an assessment, I was very, very depressed, and we kept telling the doctor I was depressed, and then all of a sudden something happened, and this big taxi arrived, and all these people jumped out, and it was like, and you know, after 2 hours they said, "Mr. Gilbert, you're depressed," and I said, "No shit." You know, like, because if there's some kind of, you know, realization that I hadn't had, this going back to the idea of the fusion, and you know, one of the conversations we were not allowed to have during the break was around.
She was quite strict about that, weren't you? Yeah.
So I'm glad you're coming back to it. I want you to have a conversation.
I willingly complied. No fingers were twisted. But it's around Northern Ireland, and you know, Northern Ireland, it's written into their law, but we don't know if it works yet. And that's not. I really hope that it does work, because it would be great to have that example, and then we can kind of go, right, let's follow that. I think it's just really tricky to say, let's do away with what we have, which clearly has a lot of issues, but also still acts as a massive security measure. Because if you were to say that somebody could detain me with fewer laws, coming from a Black community, which, you know, the mental health act has ravaged my family, not on your life, because it's bad enough as it is. So again, you know, these are conversations that we had all the way through. And again, we were, and Simon, you know, and I remember we actually went to Mark's house up in Liverpool. Mark was one of the other vice chairs, and we spent the night going over all of these core arguments, and it was a moment that I'll never forget, because we knew we were doing something really important, but we also, I think there was a recognition that we can't change the world, we can only try to move it forward. So we can move towards, you know, the position that would open up the UNCRPD, and you know, but that we just can't make things dramatically different from what they are, and this is progress forwards.
I think we did a bit more.
I kind of feel we should. It's 34. Well, have the last word, and then we'll
Okay, I was just saying, I think we did a bit more than that, actually. But I think we were the first, and we've had a lot of praise as well, who actually said, we think we're not going the whole CPRD, because actually we think a lot of it's good. We actually think it isn't the final direction of travel we want to be in.
Agreed.
And we got a lot of feedback from the legal community, and lots of people. I would say the vast majority was at least someone said that, and it's very ironic. Thank you for seeing that bit. I wrote that bit. I was really pleased.
Good. I'm glad
But
I quoted you.
How funny it was that the government says we are 100% committed to something which they know is unenactable. We were 50%. Which,
Yeah.
I thought that was extremely amusing.
Governments like to say
Yeah.
things.
I know, but
Actually,
actually,
try to do that. Oh my God! Can you
Some
imagine,
governments
can you
are
imagine
more
what would
than
have
others.
happened?
I know, but
I-
Richardson's committee's report just sat on a shelf, you see, didn't it, Ginevra's? You know,
Yes.
the government just completely ignored it, and at least you've
And-
got some traction.
And what was really
And,
important,
yeah.
we did quite a lot of work. We went to see, talking about Scotland, we went to see Theresa Angelino, who's told every single one of her reports on mainly criminal justice has been accepted. And I went and got a tutorial from her on how does that happen? And she explained what you must do. And from day one, we're always thinking about how do we land this in 2 years' time. And you're quite right. And Ginevra had a terribly difficult time, and she did a great job. But in circumstances that were actually almost impossible, and we had a much easier time for all sorts of reasons.
I mean, the interesting is, you know, also I just want to acknowledge that lots more questions popping up in the chat. So, but I'm going to wrap it up. So I'm just going to mention some for us and everyone to think about. There's a question about whether people thought about whether it would be okay for section 136 to be used by the ambulance rather than the police, whether that would be appropriate.
We did have
There's
that
another
conversation.
comment. Sorry?
We had that conversation.
You had a conversation. They had a conversation with comment. There's another comment on, you know, how awful it is that things are people left in the community until it left escalate to the point where they get sectioned, but help is not available before. We have to some more worries about extended periods in hospital, but you know, we have to wrap it up in the interest of time. So I want to thank all of our panel for, you know, great contributions, great discussions, even if you were a little bit unruly. No, really, I think it's fascinating. I want to thank the audience for joining us. In the chat are further links about the rest of this colloquium. We have a series of events on Thursdays this slot, and not every week, on philosophical issues related to the Mental Health Act and psychiatry more broadly. So please join us for that. And I think, I mean, you know, I'm sure the panel, people in the room will have a chance to talk about this more, but, you know, I think we should cut the microphone. But before we do that, anybody who wants to please unmute yourself and give a round of applause. I'm going to put. I have lots of thank yous in the chat. So thank you. I think we can.
Thank you for chairing.
Yeah, well done.